do that and then pull up the document. And we should be good to go.
Great. Welcome everybody on the live feed. We are in the Civil Law and Procedure Subcommittee. It is Monday morning, March 8th, 9 a.m. Welcome to Delegate Moore and Delegate Malone and Delegate Grammer, who decided to go on legislative time instead of actual time. Thank you for showing up. We are going to start with House Bill 23. You will recall we actually already passed this bill in subcommittee, but we have not sent it to the full committee last week or 2 weeks ago. I'm bringing it back for the purposes of an amendment after discussions with the library services, which is the entity that would be inquiring on the reports that we are requesting through this bill of the different agencies in terms of inquiries as to whether they got a inquiry from ICE. We were concerned that it was too broad and it was going to not be able to be accomplished. So I am sure that this is something that will make some of my colleagues here on the committee happy, but I'm going to propose an amendment that's going to narrow the legislation. And Holly, correct me if I'm wrong, or maybe you can take over, but the issue is if we require every agency to report, there's no way for the agencies, for all multi-hundred, possibly 1,000 different entities in the state to know that they have to report and then when they have to report. And
exactly. So Andrew, scroll down. We can show the members exactly where this is. Keep going. Keep going. Okay, hold on, slow down, let's see. Keep going, sorry, a little bit farther. Keep going. Okay, here, so everybody look at paragraph 3. So as it was drafted, it just said, if an agency, a state or local agency received a request, then they had to report. The issue is we have a tracking system. So the tracker who lives in the library would not be able to, know who should report or if they're not reporting. So there was no collection process and it did not have a mandatory reporting date. So the reporting requirement was basically moot because we wouldn't know who to follow up with. They have no date of when they actually need to report. And so the library reached out and just said, there's no way for us to actually do this reporting requirement. So what the delegate did is added the 3 agencies there that you can see and added a mandatory reporting date.
Right.
Like they have the MVA, the state police, and the Department of Public Safety and Correctional Services. So then those 3 are 3 distinct entities that we can follow up with. They have a date there and it makes it actually a valid reporting requirement.
And per Delegate Grammer's oftentimes request, although I don't believe that a sponsor should have any influence over a bill once it's in committee, but I did check with the sponsor of the bill and with his staff and staff in ENT because they're the ones who originally had drafted some of the language. They were okay with the amendment. What the amendment, as Holly had already said, the amendment does is it only defines in just 3 agencies that we're looking at. That's what the amendment does. Any questions? All right.
Actually, Mr. Chair. Oh gosh, sorry, my dog.
If let me make this clear, so that if we don't pass this amendment, all agencies are going to have to report, and that was one of the issues I believe that Delegate Grammer had. So I think that this is going to be considered a friendly amendment. Is there anybody who doesn't consider this a friendly amendment before we vote? I just want to make sure.
Mr. Chair,
Sure.
I got bumped off with my feed. Could you just explain the amendment real briefly?
Holly, why don't you re-explain it really fast?
Sure.
Since
So
you
Delegate
disagree.
Cox, there was an issue where the language as the bill was drafted said any state or local agency, and that's any state or local agency in the state. Based on the reporting aspect, there is no massive list of any state or local agency that might need to report on this. And so, and it also did not have a mandatory reporting date. It said if they received a request, they should report. Well, there is somebody internally that takes care of all of these reports for the General Assembly.
It would
And
it would be onerous. It would be onerous on her to try and do
well,
that.
it's impossible, I think, was her point, because she wouldn't know who should report, because she wouldn't know if they got a request or not. So even now, even if they get 0 requests, they will have to report on or before June 1st each year, whether it's a 0 or not a 0. And that just allows for a better reporting process. But then we had to narrow that scope down so that she can actually track the reports. You can put any state or local agency, but it goes into this category of other, and it makes it very hard to report. So then when somebody comes to get the reports, she said, I didn't receive one from MVA. Did MVA know they had to report? They might not know. Like here, they're getting notice. They know that they're on for now a new reporting requirement through this legislation.
And it only requires 3 agents. It defines it into it 3 agencies, so that it becomes much more manageable and not a burden on the 1,000 independent and local and municipal agencies around the state.
Excellent. Okay, thank you.
And Delegate Cardin, I just wanted to clarify. So the subcommittee last meeting wanted to clean up the definition of law enforcement agency. And Andrew, I think that's a little bit farther up, just a smidge up. Let me find it. Maybe it's farther down. I'm sorry. It's hard to show you guys on this computer.
No.
But yeah, go down. There it is. So law enforcement agency at the bottom of the page. Keep going down a smidgen more, Andrew. And then it has Roman item 1, 2, and 3. That is the style of the code. So taking 3 up is not going to be in the format as how we usually draft. It's going to be law enforcement agency means it does include, it doesn't include. So if I take what you suggested last subcommittee up, it's not going to be in the typical format that the article is drafted. And so I think that might create some confusion.
So you're suggesting that it makes sense to just keep it the way it is, and this will be understood in this language better by the courts. Okay. So the motion is to narrow this to add this amendment to narrow this only to the 3 agencies that that ENT and Judiciary agreed would be the appropriate ones, and not all agencies across the state. Can I have a motion?
Favorable.
Mr. Chair.
Is there a second? Is there any more discussion, any question?
Yeah, so discussion, Mr. Chair. So could you explain why law enforcement is included in this amendment when they're striking criminal and focusing on just civil immigration enforcement, but then they're inclusive of criminal enforcement laws in the law enforcement agency definition? I'm a little confused on that.
And Holly, you're going to have to correct me if I'm wrong, but my understanding is that they're included too, so that you know who is going to be able to be who's going to be required to report if an agency does get an inquiry.
Exactly.
So
Yes.
the only agencies now that are going to be required are are corrections, the MVA, and the state police. Is that my understanding, Holly?
Yes, and Andrew, if you want to scroll down to show Delegate Cox that section, that's as the bill was drafted. Nothing really has been amended there other than just me clarifying that the definition can't change, that it does not include United States Immigration and Customs. It does include the Maryland Department of Public Safety and Correctional Services. And the Department of Public Safety and Correctional Services is one that should report. So they just wanted to differentiate who's included and who's not included in that law enforcement. That makes sense.
The definition is only for reporting purposes.
Thank you. I see that now. Thanks.
Okay, there's a motion, there's a second. I'll do this the way that I think it's just easiest. Anybody opposed to the motion? Raise your hand. All right, I'm going to assume that everybody then is in favor of this motion. If you want to stay non-committal, let me know. Very good. So the motion passes. Now, I am happy to hold this a little bit till till we get clarification from Patrick that there's no other amendments. I think that maybe we just
There's no more. I
right,
spoke
but
to him last night.
I got a text from Dana this morning.
Oh no.
So
Maybe
I just
so.
want to. So hold on one second. Let me just say.
Yeah, I had spoken to him last night. This was it. But if there's more coming, then yeah, we want to hold on to it.
So I just want to, double verify. Maybe we can have I want to have any discussion that we need to have now, but I'll hold off and see if there's any issue that Dana has.
Great.
Mr. Chair, I had a question.
Sure.
I don't know if it can be answered now or maybe when we get some clarification from ENT. When you pick the when you know the request was made in that relationship, I guess, between MVA and the agencies, how does someone actually know that though? I guess I'm a little confused. You get what I'm saying?
How does somebody know?
Like there was a transfer of information, I guess. You just have to request.
So now, if a request comes in, these agencies are going to know that they need to just keep that information stored so that they can report it at the appropriate time.
Okay.
So that we can gather that information and know. I think that the intent of Delegate Stein is to have the information available so that we can make proper policy in the future if we need to about other agencies and about whether we continue to share or refuse to share information with federal agencies. That's basically that's what I think.
I got it. Thank you.
And this is a joint, just so it is a joint bill. ENT has had this bill for a couple years now. This is the first time we got it. It was because they expanded it. And that's how we kind of got it. And that's why Delegate Stein has been so involved. And that's why Patrick's so involved, because this bill has really lived up there for the last couple years.
Okay. All right. So we'll see where we'll just verify it. And if at the next meeting, we will either vote it out or deal with whatever he's got stored. Okay. Holly, are we going to go in order that you listed, or are we going to go? Is there
It's
a particular
completely up
order?
to you. Completely up to you. However you want to take them. The only one we have to hold is House Bill 1261 is the electronic wills. And I heard from MSBA, the two section councils, real property and ENT, are working out amendments. So we probably should hold on to 1261. Delegate Fisher, that's yours. Electronic wills until I get some amendments from them.
Yeah, that would be great. And then Delegate Cardin, I put the request to Dylan, but I did have another, I have one of my experts from the panel who would also come in just to ask questions. I mean, I can answer some questions, but I'd like to request an expert to be with me on those when we come back to discuss those after we have the amendments, if that's all right, Mr. Chair.
Let's see.
Dylan said he gave the okay on that this morning. If that's relevant, Mr. Chair.
On which bill?
On my request, Mr. Chair, to bring an expert with me.
Oh, yeah.
and go
No,
over
I
these.
understand.
Okay.
That's fine. I have Mr. Anton also here on another bill, just in case there's a request, and I asked that he be allowed to be in. So that's fine. So do you want to take up that bill and discuss it?
We could discuss it briefly if you have time, Mr. Chair. I know you're against.
Why don't we go?
There
Why
are
don't we go to?
amendments coming, so.
Okay, so why don't we hold it then, and we'll see if we have time at the end. Okay, 308, SLAP
Okay.
legislation. This came in a little different than it did last year. We passed it last year.
Yeah, so if we want to bring that up, I don't know if Andrew want to screen share and just bring up House Bill 308. I can actually tell you exactly what was pulled out. There's only one part that they took out, but it is a significant part. That's how it went out last year, and it's now been amended to take one section out. So if you want to screen share, I can show you, Andrew, where that is. We can talk about it.
Okay.
Holly, what was happened last year with the bill? Did it not pass the Senate, or did it?
It just died. It died with COVID. It made it off the floor, and then I think just with everything happening.
Yeah.
And I can actually, I'll tell you the vote. Let's see, because I had it.
Yeah, and if I could say something about this, Mr. Chair. Last year, as you remember, you worked hard on this regarding some of the different questions in the hearing, and then I think Delegate Moon brought forth some language from Washington, D.C.'s similar law that protected some of the objections that we had for the First Amendment and some other issues regarding a motion practice. And my concern is that I think we had a deal last year that worked pretty well. It was very reflective of the DC law, which probably is what garnered our votes. This year, I think that's been watered down in my reading of it. And then a significant section was taken out. So I'm just concerned about the current posture. Sure.
Well, I would be interested to see how the posture that it left the House last year, and if this is going to be the will, as far as I'm concerned, the will of the subcommittee as to whether we want to, whether we want to return it back to where it was. But one of the things I will say about it is that removing the bad faith clause is something that has brought up some concern among many people. I believe that there was a bad faith clause in it last year when it left. Is that true, Holly, or not?
So let's bring up, is this the bill this year? Yes. Can you bring it up, Andrew? Just open it. Just go down to, just open the actual bill, 308. You can even just click it at the
Up at
top.
the top left, you see HB 308.
Yeah, is it not? Oh, hold on one sec.
Sorry, I should have sent that one to you too.
No, he did it. He
No,
did it.
no,
and then he-
no worries. That was my mistake. I was on this, but it wasn't sharing this screen.
Okay, so the part that is out, scroll down.
Yeah.
Everything as we passed it is in except, keep going down. All right, oh, so go back up. So, oh, okay, go down a little bit more, paragraph 2, Andrew, on page 3.
Got it.
The lawsuit.
Okay,
right.
here. So how we passed it last year, it said the lawsuit involves a defendant who, paragraph 1 was intact, and then it had, if you go down to item 2, number 2, is
Made a statement.
alleged to have a statement or engaged in conduct that, and that's the only part we had. Everything else after item 1 was stricken.
Sorry, guys. Can you hear me?
Oh, thank you. Hey, Ron, how you doing, buddy?
I apologize.
That's all right.
That meeting was not on my calendar. I was in the car driving.
That's okay.
And, I apologize. There's nothing I wouldn't do for you, my friend.
We're good.
All right.
Delegate, we're looking at SLAP suits, House Bill 308, and we're comparing what we sent out last year to what is now in the bill. So that paragraph 2 is what has been changed. Everything else as we put in the bill and amended it is there except that language. So they just put back in essentially item 2, 1, and the full 2 versus what we had, which was just primarily engages in the business of selling or leasing goods or services, including insurance, securities, or financial instruments, and is alleged to have made a statement or engaged in conduct that disparages a business competitor's business operations, goods, or services. We struck that middle part of 2. Now, the other changes we made, they have kept those. So I think the question is whether or not you want to go back to the bill as it was passed out last year or other changes, or look at it as it's drafted now.
So in the bill as last year, it was part 2, made a statement or engaged in conduct that consisted of representations of fact about a defendant or business, competitors, business operations, goods and services was not in the bill last year?
Well, it was. We took that out and we clarified to just have it start at is alleged. If that makes sense. So we took out in the amendments that when we were in subcommittee, we took everything out from Roman numeral 2 through services in line 23.
Services.
So starting at page or on line 16, Roman numeral 2, down through services in line 23, and then is alleged just moved up and became the new Roman numeral 2.
I'm not understanding that.
Okay,
What's
so
tricky,
now
Holly,
let's,
can you-
yeah, say it again.
even though John and I are lawyers, I'm not sure what it does. Can you simplify and say what it did before and what it does now?
So what we did is we took out made a statement or engaged in conduct that consists of representative effect for the purposes of obtaining approval for promoting. We changed it from made a statement versus now just alleged to have made a statement. So you've broadened it, I guess, and what went out of the committee. So if you strike, I don't know if Andrew can just highlight, made down through services in line 23, is alleged became the new Roman numeral 2, and you took out all of those requirements. Made a statement or engaged in conduct for the purpose of table approval in the course of delivering the defendant's goods or services, to just say is alleged to have made a statement or engaged in conduct.
Okay, got it.
Do you see? Hold on, because I'm looking at my copy too. It's hard to screen share and show you both. So hold on, Andrew, let me make sure you got it.
So what this year's bill does over last year's bill is broadened how
So
many?
Andrew, don't highlight, so go up to line 12. Sorry, your page numbers are different than mine. Go to page 12 and strike made all the way down to line 12, strike made,
Mhm.
and then all the way down to services in line 19, I think. it
Line
is.
21, in line 21,
Line 19. Nope,
line
just
19.
services in line 19.
Okay.
So made down to
Okay.
services,
I got you.
and then is
Gotcha.
alleged becomes the new Roman numeral 2. And
Okay.
that is what went out of the committee
Last year.
last year, yes.
This year, the made a statement is now
Back
included.
in. They brought it back in. You actually struck it in the subcommittee. It was part of those discussions with Delegate Moon, and I mean, I think we
Right,
covered.
that
the
was what
schools for
Cox, I think that's what
2 weeks.
Delegate Cox is talking about, right?
Yes.
That's, okay. So that doesn't bother me to strike that again. I personally, as a delegate, have no problem with that.
I think it
And
should stay.
what's that?
I think it should stay.
The lawsuit involves a defendant who, so it's, you're broadening the amount of lawsuits then that can be,
That are covered by this bill, correct?
Yeah.
If you strike it.
if you, no, I think if you keep it,
Well, see, I think it can, no, I think it, because now you just have to say, now it's just is alleged. And if you keep made a statement, that I think that constricts who it covers.
Yes.
I agree
Delegate
with
Malone, I think you're right. We broadened it last year to
Yeah.
it's alleged with, and you won't have all those components. The made a statement, the very strict purpose, and in the course of delivering the defendant's goods or services. Now you just need that alleged bar.
And I think we should take,
And
a baby
saw
step
passed
into
out of
passing
committee.
this, a slap
Yeah.
loss.
okay. All right, so you want to keep it then? You want
Yes.
to keep that language?
Yeah,
All
and I
right,
want to,
and Delegate Cox, you want to keep that language?
I do, yes.
Okay, because my understanding was that you wanted to strike that language.
Well, I think I misspoke because last year the focus that I was looking at included more of the motion practice, if I recall. And I don't see that language
Well,
here.
we can get to that. There's there is my understanding, and you have to help me find it, Holly, is that we struck in this bill, we struck the bad faith language. That it doesn't require a demonstration of bad faith.
You go through and see.
I want to verify, and if that is the case, I would suggest that is something that we at least need to discuss.
So let me find it in last year's bill and just make sure they kept that in. The targeted voting. I think it is out, Delegate Cardin. I think they brought in, I'm just comparing, I'm looking at, it was House Bill, if anybody wants to look, it was House Bill 379 last year. So I was just looking at the third reader to make sure we aren't missing anything in this one. Nice.
So I just want to clarify this with Delegate Malone one more time. If you look at where this paragraph 2 that you're suggesting we keep in, this is what a slap suit is not. So we are saying that a slap suit is not here, this specific language, versus just something that's alleged to have been made a statement against, that is conduct that's disparaging about a business competitor. So you are making it more specific as to what a SLAPP suit is not versus, so I think you are actually limiting it versus expanding it.
Okay, and I hear you, John. So let me, okay, so
Go back up. If you go back up
it
to,
says a lawsuit involves a defendant. Who is the
just go back,
is
go
the
back
defendant to a
up.
SLAPP lawsuit, or is it a defendant to?
So if you go back up to page, I guess it's page 2, line 27, Andrew, and you look, page 2, line 27, a lawsuit is not a SLAPP suit if, 1, the lawsuit is brought in the public interest on behalf of the general public, or 2, go down now, 2, the lawsuit involves a defendant who, and then you go down and you just say alleges to have made a statement.
I agree, John.
So if you leave that language in, you are creating an opportunity for more SLAPP suits. Again,
thank you, John. I agree, and therefore I want there to be. I want to take for there to be baby steps further to being SLAPP lawsuits.
So I understand that, and I'm just suggesting that if that is what you are interested in, you want to propose that we strike this language as we did last year.
I agree. Thank you for clarifying.
Okay. Delegate Cox, you might want to check that and make sure, because you're just a small town lawyer from Frederick, I know, but
I appreciate you going back to the other page because that reverses, the thinking. So I do agree. Yeah, I go with Delegate Malone and you on that reading.
okay. I'm not making the motion, but if somebody makes the motion, I understand.
All right, so moved. So moved to take it back to last year, to remove from made to line
Services.
to line 19 the word services.
Is there a second on that?
I second.
Okay. Is anybody opposed to that amendment? And let me look and see. I got to look at everybody's pictures. Anybody raising their hand? No. All right. So we're going to strike that language. We're going to narrow this slightly as to what can be construed as a SLAPP suit. Okay. Can we get back to the good faith? I mean, the good faith, bad faith. So
Scroll down, Andrew. Now this looks like it's all the language we had from last year.
So this is on page 4, right? This is where we were getting into the motion.
Yes, and we put this in. We had targeted discovery.
Right. Can I ask a question to the group? Page 10, page 4, line 10. Is there any reason why we have a shall in terms of paying expenses versus may? I'm sorry, line 14. Line 14. If the court orders dismissal of a SLAPP suit under this section, the court shall award the moving party costs and reasonable attorney's fees.
So last year, Delegate Cardin, we struck that.
We struck that last year?
Yeah, so last year we have just Roman numeral 1. And it says.
So we didn't have Roman numeral 2 or number 4.
Hold on, I'm looking at it right now.
You're saying?
So what we did is in number 4, the expenses occurred. Yeah, we took out, we just had, in last year it says, if the court orders dismissal of a SLAPP suit under this section, the court shall award the moving party costs and reasonable attorney fees. And then it says Roman numeral 2, we struck, if the court finds that a motion to dismiss is frivolous and solely intended to cause unnecessary delay, we took all of that out. So what they did, they just kept Roman numeral 1. I see. So it was in there last year. We left it in like as it is now. We took out the frivolous lawsuit component. And they don't have that in there this year. So they brought this back, but took out what we amended out, including frivolous lawsuits. So
it's the same as it was last year.
Yes, it is.
So here's my question is, do we require the court to order attorney's fees, or do we give the court discretion? That's number one. And number two is I'm going to tell you, and I think if you look in the original bill from last year, there was a requirement that you show bad faith on this part of the defendant. I'm sorry, on the part of the plaintiff.
I think the bad faith needs to go back in, needs to stay in.
I feel the only reason I say this is I had a couple people come up to me and tell me that we took out the bad faith language, and I want to just, maybe we didn't have it in last year.
Well, it's already in the statute, I think.
So I think that was what I was talking about. Is this the Roman numeral 2 of last year? If the court finds that a motion to dismiss, no. I'm just looking for
it might already be in this. It's already in the language. It's already in the language of the statute. No, it's already in the language of the statute. Where are we? Page 2. Here we go. Here, yes. So page 2, line 3. Brought in bad faith is taken out, and instead it's just brought against a person based on an act or a statement, the person that was done or made in furtherance of the person's right to petition free speech. So the question is, do we add the bad faith back in as language?
And just for clarity, as it passed last year, that was out. So Delegate Cardin, you were right. We passed it with that language out.
That language without the bad faith clause?
Yes. That as drafted, it came in with that same part stricken, and we left that in subcommittee that went through as it was.
Mm-hmm. So basically that's the heart of the bill, to be perfectly frank. I mean, it's to take the bad faith out so that you can file you can dismiss a SLAPP suit even if the person's doing it without bad faith. Let me just give one example, and then we don't have to vote on this today, but again, let me give one example. Somebody writes a nasty article about me that I am having sex with children, and or somebody puts that out in a blog or on a Instagram post. You know, John Card's a terrible human being. He's having sex with children. Then somebody at the Washington Post, the Baltimore Sun, or wherever decides they really just don't like me, which, by the way, happened a few years ago, where there was an editor who just did not like me for whatever reason. And they just say, people in Maryland need to know that this person, that he's been accused of having sex with children. They didn't have any evidence except for this thing. They just think that people need to know this because they don't think that I'm a good person. So they put it out there in the Baltimore Sun, and then my reputation is destroyed because all of a sudden now there's allegations of me having sex with minors, and I then file a lawsuit against them, and they have it dismissed. Why? Because their reporting was not in bad faith. There was no bad faith there. It was legitimate. They saw it, they reported it, it's their duty to report. That's my concern. That would be my biggest concern about the not having the bad faith clause in there. Obviously, I like the legislation and I want to be able to do it, but I also worry that that we may be not taking baby steps here. So that's my concern. Now, where I am. So that's my thought.
And I think the bad faith language needs to stay in for my continued advocacy for the baby steps.
Okay. By the way, I just got a text message from Delegate Stein that as long as that it was about those amendments that we discussed. So he's okay if we want to move forward on the Stein bill, just FYI. Okay. So
Delegate Carden,
yes.
can you walk me through how the bad faith clause applies in your example?
Well, if the whole point is that if they got a legitimate tip or an illegitimate tip about me, and they just wanted to post it or they wanted to write about it, as long as, I mean, I think they survive a bad faith argument because they say, look, all we're doing is reporting what was written in Instagram. And that's how they reported it, that, as was reported in Instagram, Delegate Carden is alleged to have da-da-da-da-da. Is there any bad faith in them doing that? As opposed to, I mean, is there any, if there's no, if there's no bad faith clause, then that survives. If there is a bad faith clause, what I was trying to say is that I think a judge could say, wait a minute, you as a legitimate newspaper would be, you've got to do some research, you've got to verify, you've got to get corroborating evidence, you got to do something except just reporting out there. That's what I was trying to say. So so it would not survive a bad faith test if they did that.
I think
Now, it
Mr.
might survive
Chair,
anyway if they did do, a little bit of research and found out, oh, wait a minute, these allegations have been going on now for 10 years and we think it's legit and whatever, fine. But, I'm just.
Mr. Chair.
Yep.
I think it's even worse than that because, and that's why I agree with Delegate Malone to keep this in, because it's not necessary. It's not, the law is not focused on whether or not the newspaper was acting in bad faith, but on whether or not the person trying to defend their reputation was acting in bad faith. So if they're acting in good faith to say the newspaper knew or should have known that this was patently false, and let's say they try to make that case, now, if you remove this language, you really can't even take a case in there because basically they can print whatever the hell they want to, because anything is viewed as fair game for dismissal, not whether or not you acted in good faith in filing a lawsuit. So in other words, if you even have evidence that shows that the statements were false or that they knew or should have known that it was a false source and they reprinted it or whatever, even in that situation, even with that evidence, they could file a dismissal of that suit and there would be no standard to prevent the dismissal. So I agree with you.
Okay. All right. Holly, do you understand what we're trying to do? It's just put in that language. It's just a couple words.
Yep, so basically we're gonna strike the bracket in line 2, and then I guess.
Or just add the in bad faith.
Paragraph 1 back in.
Just add in bad faith after brought in line 12.
I think you got to strike the brackets, Mr. Chair.
Yeah, I think I have to put in,
You think you have to put in the old language?
I do. I don't think we need paragraph 2. I think I need paragraph 1 to fully
Right.
explain. So paragraph 1 would come back in and then we could go down to brought. I mean, I would just put the bracket back in before paragraph 2 down through where it is now, right after rights. So you're just putting back in the bad faith clause. I can check it, Delegate Carden, if you want. I can draft it up and you all could take it up again as
Yeah.
amended.
Why don't we're
Agree.
not, I don't think we should vote until we have the language to make sure
Sure.
we're good. But I just wanted to, so we're good
Okay,
with
so
that.
let me put it back in and check and see. I understand what you all want to do, but I want to just look at it in detail. But we'll put back in the bad faith clause. I'm going to put back in that paragraph 2 that as we passed it last year, the only question now is the attorney's fees.
It's just a question. I tend to like to give judges just discretion. I was just putting that out there as a thought. It's not as, I mean, we've never had that. We've always had it be shall. That's how it passed last year. So
I think it should be made, though. I agree.
you can make the motion if you want. Do you want to?
I so move to make it a may and not a shall, to give the judiciary discretion.
Second.
Second.
All right. Anybody opposed? Well, let me, well, I have a feeling there's gonna be some people opposed. Andrew, can you take the thing off so we can see everybody? Everybody can see me? Thank you. Everybody in favor of making attorney's fees discretionary, raise your hand. 1, 2, 3. And anybody opposed, raise your hand. 1, 2, 3, 4. Okay. And abstaining is Delegate Conaway. So we will not change that language, but we will take up the bad faith clause as we move forward. Okay. Can we go back to House Bill 23? And I'll just, I know that there's a couple people not on before. House Bill 23 was a bill that we discussed previously. It's Delegate Stein's bill that requires reporting of when you get requests or inquiries from ICE on particular individuals. We did discuss and pass an amendment for those of you who weren't on the call. The amendment narrows it tremendously to just 3 agencies instead of every single agency in the state. This was per the advice and counsel of Library Services and ENT, which it's duly assigned to. They have approved that amendment. And the amendment just limits it to Department of Corrections and the MVA and the state police. I now have gotten a text from Delegate Stein saying that was the only thing that he cared about. He was just, I think he was just inquiring to make sure that we did deal with that amendment. Not having spoken to his staff, I guess, I'll blame it on him. So I'm gonna ask, I'm gonna move or ask for a motion on the bill as amended. Is there a motion, Delegate Fisher?
Yes, so moved as amended.
Okay, is there a second? All those all those opposed to the legislation as amended, raise your hand.
Discussion?
Yep.
Is there
Discussion.
Chair?
Go ahead. Discussion.
So, Mr. Chair, I really am concerned that we're doing 2 things in this bill that are both endangering Maryland's public. First of all, we're tying the hands of federal officials, which I think is a federalism problem, where we don't have authority as a state to tell the federal government that they can't enforce the laws under the, under the supremacy clause. And then secondly, this will most certainly allow for people who have committed violent crimes in Maryland to not be picked up otherwise. And I know that there's an intent to focus on nonviolent offenders and those who are here undocumented and illegally that are not violent. But I think that this is going to have severe effects on the safety of our children and our neighborhoods, including the neighborhoods that most especially want immigration enforcement. That would be many of the minority and immigrant communities. So I urge that the committee take a pause on this and really examine this to make sure it's actually narrow enough and to make sure whether or not it actually passes constitutional muster and actually protects the most vulnerable. So with that, I would urge an unfavorable at this time.
Delegate
Mr.
Conaway.
Chair, could I? Oh,
Delegate Conaway first, then Delegate Fisher. You're on mute, Delegate Conaway. You're on mute still. You're still on mute. Okay, there you
My
go.
question is, with all the people here that are undocumented, so we hear about, where are they working? Who are they working for? It's an underground employment situation that's going on, and all these people are not criminals. Some of them are being actually used unfairly. So that's my question.
So yeah, I don't think that this bill is really gonna directly address that, but what it is gonna do is we're gonna find out if the Department of Immigration is reaching out to the state police or the MVA to try and find out information about them.
Well, I was just saying it's not fair, I don't think, to characterize everybody here who's undocumented as being criminal
Right.
or potentially dangerous. That's all.
I agree.
I wasn't doing that. I was talking strictly about those who are criminals, who are dangerous. This also protects them, and that's the problem.
I understand. Well, I understand your perspective, and I would agree with you, Delegate Conaway. Delegate Fisher.
Oh, sorry, my camera's a little loud. Mr. Chair, you can hear me, right? Sorry.
Yes.
Okay, yes, I just wanted to respond to the comments, I appreciate the comments that were made on this legislation, but as the person that actually lives in that minority immigrant community, not only being a child of immigrants myself, but just my entire district is the probably one of the most diverse districts in the entire state and has the largest immigrant population with status and undocumented. I would say that people, as Delegate Conaway pointed out, are hardworking people. We need information on these sort of requests. And I would also say that this, not only did the Maryland General Assembly, but the voters of Maryland, because it was a ballot referendum for driver's licenses for Maryland residents who pay taxes for 2 years, we informed residents that if you pay tax and you get a driver's license and have insurance and all of those reasons why we passed that, it wasn't said your information is just going to be sent off. And I think that's part of the nature of this bill and what we did as a state and what the voters asked for of us. So I would encourage my colleagues to vote yes on this bill. It's been worked on before. It is limited in scope, and it provides that surety for all Maryland residents. So those are my comments, Mr. Chair.
Thank you. Any other comments or thoughts? All right, the motion, I believe, is favorable with a second. And I'm gonna just, let's do a hand vote. All those in favor, raise your hand. And Delegate Watson, if you can hear us, just yell. Okay, great. 1, 2, 3, 4, 5. And all those opposed. 1, 2, 3. Very good. I'll only say, just for your information, I do not believe that these votes are recorded, although they are public to see. So thank you all very much. And for the second time, we can now say this was a spirited issue, and I know it's going to raise some concerns in the committee, but But I think it's the right policy to go, and I'm looking forward to us passing this legislation. Okay, where are we next? We're gonna hold off on SLAPs because we've got amendments on it. 405. House Bill 405.
And Andrew, if you could bring it up so all the members could see, 405 is
Sure.
also a joint bill with Ways and Means.
Okay.
They voted it favorably last week.
What was their vote? Holly, do you know what their vote was?
We had this bill last year as well.
Hold on, Delegate. Let me pull it up, okay? Yeah, we did have it last year, and I believe it got stuck in subcommittee. I'm not sure if that's because of COVID or what. I'll have to look up the file.
Well, I think there was some very spirited discussion about this bill, which we will have. We may or may not vote on it today, but this is, and it did pass out of Ways and Means last year and did not pass out of our subcommittee last year. That is correct. Are there any amendments before we get started, Holly?
No, there are no amendments. And I'm just looking for the vote sheet right now that Dylan
Bill
forwarded.
authorizes a court to award reasonable attorney's fees and related costs, including expert witness testimony fees to a parent of a child with a disability if the parent prevails in a proceeding that is held to resolve disputes about the identification, evaluation, or educational placements of children with disabilities, or the provision of the free appropriate public education. It may not be made, the fees and costs may not be granted if after a written offer of settlement is made to a parent, unless the parent was substantially justified in rejecting the settlement offer. That might be
The vote was unanimous. Sorry to interrupt, Delegate Cardin. It was 21 with 1 excused.
Out of Ways and Means?
Out of Ways and Means.
So,
and it was a straight favorable.
So for all the attorneys on here, what would be a reason not to, this is a shall, this is a required attorney's fees if you prevail.
I would
Why?
rather, I'd rather it be a may.
Well, I'm asking you, is there a reason, what would be the reason why you don't grant, is it always discretional in the past, or is it you never could get attorney's fees and costs?
You probably could only get attorney's fees if it was bad faith, because that you often can only get attorney's fees unless they're statutorily allowed, or if it's a bad faith case. If we make it may, once again, it would be a baby step towards being allowed to do it.
Here, Maryland regulations authorize but do not require the court to award reasonable attorney's fees to the prevailing party in a due process dispute under circumstances described in the specified provisions of IDEA statute and related regulations. IDEA authorizes the federal district court for Maryland or the state circuit courts in the counties to award reasonable attorney's fees as part of the cost to the prevailing party, which may be the parent or may be the state or the local agency if the parent's complaint or the cause of action is found to be frivolous or presented for any improper purpose. Well, I think that what this does is it includes expert witnesses, which never was included before, if I remember correctly from last year.
So Holly, do we have any data on how many lawsuits of this nature are brought in each of the counties? Because I can tell you, in my county, there are many lawsuits like this. And so I would be concerned about the coffers of, the Board of Education, and possibly maybe even considering maybe a cap on the amount that could be awarded, or even excluding the expert testimony, but something maybe based on that. Again, I just don't know what other counties experience, but I do know there are quite a number of those kinds of lawsuits presented yearly.
Mhm.
Does
Yes,
anybody know, any of the
delegates.
other delegates know in their counties how and what's happening?
We'll get to Delegate Grammer in a second. Anybody have a response to that?
I'll just say, Delegate Crutchfield, I don't have any of the data. I mean, I'm looking through right now. I don't see anything where that's reported. But I do recall that being an issue of the amount that would be going out of the school boards for paying these type of cases. And to what Delegate Cardin said, I do have in my notes that that was also an issue of contention, the expert witnesses. So two things that were touched on last year.
If I remember correctly, one of the conversations was, would there be an increase in the number of cases because you could be granted the fees, the recovery of the fees? That's question number one. And question number two is, does the issue of getting attorney's fees paid by the prevailing party, if it's determined to be a frivolous lawsuit, does that remain in the statute if we pass this bill? So in other words, if a parent does do a frivolous suit and it winds up spending a lot of time and money for the county, does the county have the ability to then recoup? It's just I don't know the answer to that.
Yeah,
So
and a lot of these lawsuits are based on the exclusion of services, so it's kind of difficult to say necessarily that they're frivolous. It takes a lot of time and energy and money, like you mentioned. So again, I'm just raising this as a concern, and just seeing if there's any other folks that.
Charlotte, what do you think about what would your thought be on a cap on expert testimony or expert fees?
I'd have to probably visit with somebody on, maybe the school board, or just find out from the.
Are we talking in the thousands? Are we talking in the tens of thousands? Are we talking in the hundreds of thousands?
I'm thinking at least it could be tens of thousands. It just depends on what the wherewithal of that family. But obviously, a lot of families are excluded from this, because they just don't have money. But I would think that it could get pretty high. I would think it could go pretty high. But again, I just don't know, in the other ways, how many lawsuits are being raised like this. So,
Andrew, you can take the okay. Hello there, Delegate Williams. I hope everybody healthy.
Yeah, sorry about that. I had a doctor's appointment this morning.
No problem.
I knew we were going to have committee.
Any other thoughts? Yes, Delegate Grammer. So we got to keep moving.
I wanted to get clarification. Is this the state paying the fees, or is this the local jurisdiction, or is this the board?
So according to the fiscal note,
because I guess the question would be, who's the defendant? And the defendant, it's the school system. Does that come out of the board funds? Where does it technically come from? Who's going to pay the defense on this?
In the great majority of due process proceedings covered by the bill, the local education agency is the party in dispute.
Yeah, but who is that?
It depends on the local school that is the defendant in the case. I think this came up last year that certain school boards or certain districts might have more cases than other districts, so that board would have more costs and fees. And to what Delegate Crutchfield said, I don't have that. I mean, I'm happy to reach out and see if we can find some of that information.
I'd be more comfortable knowing that specifically. Is it the school system? Is it the board? And this is about IEPs, correct?
No, it's more than that. I mean, it reaches out to everything involving disabilities with children.
Okay.
And I know, like I said, specifically, I know in my county, a lot of times that's a result of services. The children are not receiving the services that they should, you know.
And can someone who practices elaborate for me? Do we award attorney's fees based on, you know, some kind of negligence from the system, or is it because the plaintiff can't afford these kind of scenarios? What is good practice as to when we award attorney's fees?
I'll let Delegate Malone chime in, but usually attorney's fees are based on contractual engagements. So if it's in the contract that the prevailing party gets attorney's fees, or if there is some sort of fraud involved that gives the judge the authority to grant those kinds of the attorney's fees and other damages. So that's usually where their attorney's fees are in. It's not generally, and correct me if I'm wrong, Delegate Malone, it's not usually in statute that attorney's fees are granted. Or Delegate Williams, you might know this better than I do.
Yeah, I think you can normally only get attorney's fees if it's within your contract with the other party, that's relief that could be provided, or if it's statutorily allowed. Because, you know, they talk about the American system versus the European system. The American system is that, you know, it's not the winner prevails. It's, you know, everybody covers their own fees. European system, the winner, you know, prevails and gets attorney's fees.
Gotcha. Okay, thanks.
These people do. I mean, these are generally parents who are struggling with having a hard time with educating their kids. So on the one side, you do have, and they're up against a very, very tough wall of defense. You know, they have, you know, a big system with plenty of legal counsel, and, you know, so it's a David and Goliath issue on the one hand. On the other hand, you're, as Delegate Crutchfield said, you could be opening up these agencies to huge swaths of liability where there's finite amount of resources.
And that's kind of what I wanted to get at, Delegate Cardin, is like, I could give you a David and Goliath scenario for a lot of things. And it's about, you know, Delegate Crutchfield's comments, but it's about, you know, what about the next attorney's fees bill? I mean, I could show you tons of people that are frankly just indigent, can't afford this, and they're trying to fight an issue that, you know, there's good calls and they can't afford a lawyer. Do we give those folks attorney's fees? And that's just what I'm trying to work out
Well,
here.
it looks to me like attorney's fees are already discretionally granted. I mean, I don't know if this is limited, but if you look at the fiscal note, it says that Maryland regulations authorize but do not require the court to award reasonable attorney's fees to the prevailing party in a due process dispute under circumstances described in specified provisions of the IDEA statute and related regulations. IDEA authorizes the federal district court and other state courts in the county in which the child resides to award reasonable attorney's fees as part of the cost to the prevailing party, which may be the parent or may be the state or local agency if the parent's complaint or cause of action is found to be frivolous or presented for an improper purpose.
Hey, Delegate Card, can I ask
That's already in the law. Yep.
All right, just so I can understand, I mean, Prince George's County has a huge amount of special ed cases every year. And I thought the intent of the bill was to compel the boards of educations to ensure they do all reasonable accommodations to accommodate that swath of demographics in our school system, special ed. Now, if that case goes to court, then if the parents prevail, you're saying it's still up to the discretion of the judge whether or not that the losing party pay for lawyer fees?
That's my understanding of the law right now, yes.
And so this is kind of tricky because a lawyer could charge almost whatever they wanted. And even if there was a cap, you know, there is an amount to which that the parents can't pay anymore. And why wouldn't the attorneys just try their best to gouge and get as much as they wanted? You know, I'm trying to ensure that what I would like to see is that if a parent prevails, they were wrong and they should be able to be compensated for attorney's fees. But what's to prevent the attorneys from taking advantage of the situation?
So there's already law and case law about what is reasonable, and a judge can reduce the amounts. Oftentimes 15% of an award is oftentimes, and if you can monetize what the award would be then you can figure out what the attorney's fees would be. Or in this case, because it's a special type case, I'm sure that the special masters would have some sort of calculation or formula to figure it out. So I'm not worried about that. I think that your second concern is probably more important, which is why aren't we giving these people who have basically mortgaged their life to try and get what they think they should, the right education for their kids? Why shouldn't they be reimbursed for their efforts if they win? That's really your question, I think. Any other thoughts?
Mr. Chair?
Yep. Go
Yeah,
ahead.
I just wanted to, thank you. I wanted to agree with Delegate Watson and a couple quick points. I'm a huge proponent, like Delegate Malone explained, of the American rule. The one exception that I see is in civil rights issues against the government. Having litigated those, I can tell you that, as you said, Mr. Chair, you're up against a brick wall. And there's very few of these cases. I know in some counties they're more than other, but these are special ed kids that are generally denied, for whatever reason, services that the federal law requires. And in order for an attorney, and I've taken some of these cases, and honestly, there's no incentive for me to take any more because you just don't get paid. It's very rare. Now, having said that, there is a mechanism already for attorney's fees so that they're not going to be egregious. They're going to be confined by the court and by the law. But the other thing that is so important, I think, and I'm not trying to give props to Delegate Lopez for a bill, but I'll tell you the good part about this bill that I liked, seriously, is that it incentivizes the local school boards to make a settlement offer.
I was waiting for somebody to say that.
Yeah, because if they make the settlement offer 2 weeks before trial, at least, and at trial that the party gets no better than the settlement offer, they don't get anything, not attorney's fees or expert fees. So really all this is doing is saying, by the way, with an addition to attorney's fees, you can tack on a reasonable expert fee and cost of litigation. However, you don't get it if there's an offer to settle and you deny the offer. So anyway,
so basically it's encouraging more settlements and and quicker settlements.
I think so.
Because I think the intent of the bill.
Yes.
Mr. Chair, are you entertaining any motions at this time?
Yeah, I'll entertain a motion now because we got to move on. We're not going to get to.
I'll move favorable.
Second.
Okay. All those. So we're doing it. Okay.
Question.
Yep.
So if they offer you a settlement and you don't take it, then you get nothing?
No, you go to court.
You go to court.
You run.
You don't take it and you get not right. And if you don't take it, you go to court and you win, you don't get attorney's fees.
And how
You're talking about currently.
No, if this bill passes.
Yeah, but if it's substantially different than the settlement offer, in other words, you win really big, you get something that was crucial or material and they weren't offering that to you, then you could still prevail on the attorney's fees.
Right. But if they offer you 4 days of services and then you go and you win 5 days of services, you get the 5 days of services, but you lose the attorney's fees because they made you a legitimate offer that was pretty close.
I do have a question, and this sort of goes to the attorneys or any others. Normally, settlement discussions can't be disclosed during the trial. is there a provision that this will be a bifurcated trial so that the attorney's fees will be handled later? Because it really should be a bifurcated trial because
That's a great question. Holly, maybe, look, I'm happy to pass it. I'm happy to hold it and see, but
well, I think
you just brought up
can,
a very good point.
I can withdraw my motion, Mr. Chair, if you want to talk more time to.
Because
to that.
you can't discuss settlement. You can't have, that's not part of a judge is not supposed to know that. And maybe there has to be a separate hearing. We need to check that out.
So I'll withdraw my motion at this time, Mr. Chair.
Okay, great. So I think we're ready to go on this once we get some clarification. So that's great.
Who's going to work out that question?
Yes, I'll take care of it. I'll go back to Ways and Means, and then I'll also go to the courts and ask. So I'll get an answer back for you.
Thank you.
Okay, very good. And Delegate Crutchfield, you might want to think about the expert witnesses and just finding out what we're talking about in terms of money, because I have a feeling that the school systems are going to come batting down our doors if we find out how much. Although I will tell you, these children deserve to get the services that are constitutionally they're entitled to. So,
Absolutely, agree with you on that.
Okay.
Hey, but
All right.
expert witnesses don't fall under the same. They aren't considered attorney's fees. Would they? The fee for an expert witness?
It's considered a cost, and the bill specifies that the parents could also receive compensation for.
Okay.
Yeah.
Okay.
So yeah, I mean, it might be a consideration as to whether that remains part of the bill or not. I mean, but I think that's a big part for Ways and Means, because they think it's a huge cost. It's bigger than the attorney's fees.
Okay.
Just as a quick note on that point of Delegate Malone's good point. I think for Holly, line 22 says finally obtained. So it looks like it's after you obtain judgment, then the court holds a hearing on it. And I don't know if that satisfies it. I think that's a fair question.
Okay, thank you. I'll check into it.
All right. I think hopefully 766 will be a quick one. HB 766. This is a bill that that alters the existing statutory fee schedule that may be assessed by the Register of Wills, including eliminating the probate fee assessed for small estates, reducing the probate fees for estates of at least 50,000 but less than 250,000, and increasing the probate fee for estates of greater than 500,000. This was brought by the Register of Wills. You'll remember, I don't think there was any opposition. The fiscal note was very minimal because they don't make any money on these small estates anyway, the Register of Wills, and they can make the money they can compensate it all with the larger estates.
Question.
Yes.
What Register of Wills bought this? Did the Register of Wills of Baltimore City weigh in on this?
Holly,
I didn't have any opposition, so I'm not sure if they weighed in, but everybody seemed to be on the same page with the language.
That's not the question. I'm asking, did the Register of Wills from Baltimore City weigh in on this?
No, not that I know of, no.
Is it possible that we could hold this for a minute?
Sure. We'll hold it till the end. No problem. Is there any other questions or comments before we hold the bill? Yes, Delegate Malone.
The only question I have, and unfortunately, is the fact that I'm concerned if voting for this bill, it'll be viewed that you voted for a fee increase. And those magic words of former Governor O'Malley is, you voted for X number of fee increases during a session. Because it is a fee increase on the one end.
Right. Well, the only thing I'll say is that you're eliminating the fee on the vast bulk of estates, and you're increasing it, and you're increasing it incrementally on the larger estates. I mean, you're basically just squeezing the balloon, in my opinion. So that's what I would respond. That's, okay. Good. Yep.
Also
Delegate Cox.
dovetail off of Delegate Malone's comment. I think it's greatly increasing it, if I'm not mistaken. It's taking out $1,500 for a fee, line 10, and putting in 0.2%. So,
Right, well, so, right, so if it's a
Yeah, but
$5 million estate, it's gonna be more. Sure.
Right. So it's 2% of $5 million.
that's going to be potentially huge.
Is it, let me just see something.
That's $100,000.
Mr. Chairman,
Yes,
I have the Register of Wills of Baltimore, Maryland on the phone right now, and the Register of Wills of Baltimore, Maryland said that they voted no.
No, I voted no.
Well, she voted no.
I voted no.
The Register of Wills from Baltimore voted no.
Did they submit
Okay.
testimony, Delegate Conway? Because I don't have anything on the floor system. I just want to check and see if it came in late.
Well, the Register of Wills, did you submit
so
any?
then,
I did not submit any testimony, but I made it very clear to our association that I was not in support of raising any fees.
Any question for the Register before I get off the phone? Thank you. Thank you, Register. Have a good day.
Thank you.
So was there a justification for why they're raising the
so
fee?
by the way, I'm sorry, it's
The
not
fee is-
2%, I'm sorry, it's not 2%, it's 0.2%.
Oh, yeah, it is.
So it would be, I mean, because that did not sound right to me. So if you had a $5 million estate, let's just make sure, times 0.002,
No, I think it's another zero.
No, it's 0.02.
Point
You're right.
No,
Because a tenth would be 0.1 and a hundredth would be 0.01.
this is why I went to law school.
$10,000.
$100,000.
No, it's not 100,000, not on a $5 million. Yeah, I'm getting what Carton's getting.
Times point. Times
5 million times 0.02 is $100,000.
is $10,000.
But 0.02 is 2%. This is 0.2%.
No.
Okay.
Yeah,
0.2.
yeah.
0.2 is 2%. 0.02 is
Okay. No, you're right.
That's a huge, huge increase.
well, is it? You're going from 2,500 to 10,000?
Yeah.
Huge increase? Really?
Yeah. Did they speak to why they want that?
Well, it's making it less. I mean, it's zeroing it out for other estates. I mean, currently, if you have a state that's $10,000, you're paying $50. So under this bill, it's zero for those who have an estate of $50,000 or less, versus now they're currently paying a fee.
I don't know if that
They're
evens
reducing the
out.
fee on the people who have the smaller estates.
So
Which
I'm just looking at some of the
people who
testimony.
are probating stuff. I mean, it's going to be very few people who are going to have a $5 million estate.
Yeah, here's the thing. We could keep that. We strike it for the cheap estates. I just don't like the way we scale up on more expensive estates.
So a
We
1
have
million,
power
let me
Well,
put
it
it this
currently
way.
scales up now. It's just the scale is modifying.
And don't forget, on 5 million estates, they're also subject to the Maryland death tax. So it's not just a minor hit to go up to 10,000. Now and one of the problems that we have in Maryland is we're a lot of land rich people, but cash poor. So.
Can we hear from Mr. Anton?
No, well, okay.
Well, he's
Mr. Ann's
on.
not here on this bill. I don't even think he cares about this bill, but
Oh, he cares.
let me just say this, by the way. You go on a $1 million estate or on a $2 million estate, you go from 1,500 to 2,000, right? And on a on a $1 million estate, you go from 1,500 to 2,000. On a $2 million estate, you go from 2,500 to 3,000. So it's not that it's not a big change. It's a big change for a $10 million state or a $20 million state. That is correct. It goes from 2,500 to like 10,000. That's correct. But, you know, you're talking about, you know, very few estates there, and, you know, $10 million for the fee for the estate is not, I mean, that's what's paying, you know, these costs. I mean, I don't have a problem with it.
I mean, for the average Marylander, the cost isn't going up. I mean,
It's going down for essentially for everybody except people with an estate of $1 million or more. It's going
right.
up.
Right.
It's going up for anybody who has a state of over $500,000. Anybody who's in
It's
line.
going up. Okay, it's going from
Going up
$700
$200.
to $1,000. So
Yeah.
I mean, for the cost of inflation, I don't think that's a big jump from 750 to 1,000.
So I just pulled some of the testimony, and just to clarify, so the proposal, estates under 50,000 would pay no fee, and that they estimate is about 63% of estates. Estates from 50,000 but under 250,000 would pay a lower fee than what is now. That's
Right.
14% of estates in the state. Estates from
373. So that's already
250
78%.
Yes, and then the 250 to 500 is 13%. They're going to pay the same fee, so it's only, as the delegate was saying, it's only 500,000 plus that would get the increase.
So we're
Right.
talking,
and that's only the top. That's the top. So 77 plus 13 is 90. So there's
So
only
it's less than 10% of the estates that would pay an increase in fees.
There's an unspoken policy question here, though. If you recall, when I talked about people retiring in Maryland, you know, this is the cost of retiring and dying is part of why people just rush out of this state when they retire. And those percentages are probably accurate, but there are people probably looking at their retirement and end of life decisions and saying, my God, it costs me more to die here. I won't beat this dead horse, but it's a very
Bad
sneaky
pun.
way, and it hits people in ways that we're probably not thinking about.
that might be, but
So, and then a member asked too, so this came from discussions over the interim with Register of Wills, Orphans Court, the Estates and Trust Section, and the Attorney General's Access to Justice Task Force. And they wanted to be able to help those individuals with 50,000 or less that were having, you know, passing away or affected by COVID. It would remove those fees, and those smaller estates are the ones that were hit the most. So this is just from the testimony from the hearing.
so here's I mean, I'm not trying to put any terrible thoughts in people's heads, and then we're going to move on. But what about limiting it to a maximum of $25,000, so that basically estates of whatever it is, 20 million, whether if you have an estate of 20 million, you're paying the same as if you have an estate of 10 million.
But Mr. Chair,
Oh, I see what you're saying.
here's my concern. A fee is a tax, but especially if you're going to add this percentage in, currently there's no percent in this, because remember, these people are already being taxed at excessive rates more than most other states in the union. I mean, they can just simply pack up and go to Florida and actually pay zero tax. My concern is, why disincentivize them from staying here, like Delegate Grammer was saying, and have this percent? I don't think that's, we're already hitting them with very large percentage taxes. And when you jump it from right now, it's 1,500. If you jump it to, what did you say, 25,000? I mean, that's like a massive fee. Whereas they're already paying the state a percentage anyway. This is going to actually be taking up, the fiscal note doesn't say this, but I believe this takes away from the net value of the estate that would actually go to the state general fund, and it puts it into the Register of Wills funds. So that's an interesting question there. If you start tacking on percentages, I
Well-
don't have a problem with removing the fees, but I think that when you get up into that range, most people's houses in Maryland are just gonna, they might not have any cash for the estate, but they're gonna have very easily a $2 or maybe $5 million estate, depending on where they live. So that's not a concern.
Well, I will say this. It looks like under the current law, if your estate is $5 million or more, you pay $2,500 plus the 0.02% of the excess over that. So there's already a percentage being tacked on to those of 5 million or more anyway.
It's true. That is current law. That
I
is
just
current
think
law.
in this case, if the access to justice issue was the issue, we don't have to even get in the weeds of increasing anybody's fees. We could just fix it for the lower half of the scale and leave the upper half alone. And I think you start to avoid this question altogether. And we have the opportunity to do that. I know it's could be a matter of controversy, but we could just fix this whole issue and not have to worry about raising any fees at all.
But then how would that affect the budget?
I'd vote for that.
You're collecting less in fees overall if you do that.
Well, that was the point of the whole, that's what Holly said. It's their whole point. Was either for.
No, I thought the point was to decrease the fees for the majority of those who are filing estates, which is like 75,000 or less.
So, I mean, one possibility is to make the amount an amount specific, but just to increase it. So instead of it being 2,500 for $5 million estates, it's 15,000. At least that's what it is, and we just leave it at that. And plus 15,000 plus 0.2%, 0.02% excess of 5 million. Just leave it the same way, but just increase the amount. Be one way of doing it.
So just to clarify, Delegate Cardin, everything in the proposed fees will stay the same, except when you get to 1 million, we'll go back to the old scale, which is the 1,500 for 2
No, you
million.
would increase, right? The one from 750 to $1 million, it would be 1,500. From 1 million to 2 million, it would be, let's say,
2,500.
4,000, 3,000, double it, 3,000.
Okay.
From 2 million to 5 million, it could be 7,500, and then from 5 million up, it could be 10,000 and plus 0.02% of excess of 5 million. That's your suggestion. I'm taking that from you, Dan. And basically, that's what you are suggesting. Yes, Delegate Conway.
No, I wouldn't suggest that. I would suggest what Delegate Grammer said. That I can vote for elimination of the fees for those who need it. I think that's important.
Well, I
But
know
I
you're
don't
not
think
going
we
to vote
should
for
be
this.
raising-
I understand you're not going to vote for that. I'm just saying that would be my solution to your issue.
Well, here's a proposal though, Delegate, Mr. Chair. We don't have a proper fiscal note. I think that you should hold this until we get that. If you're going to change it in any way with the fee structure, I think we need to know exactly what that'll be, because right now the fiscal note says the state is going to get an additional 1.3 million as is. It doesn't say if we just remove the increases, since those are a relatively small number of estates, I think the state is not going to be materially impacted. So I think it'd be nice to know that number, and we could make a better judgment if we do need to raise fees, what that number might be.
I would say that, I mean, I think we can extrapolate from the information we have exactly what you want to know. And yes, some of the money might be coming out of the estate tax. That's very possible. But I think that you're talking about a very small percentage of that money, to be honest, to be perfectly frank. You're talking about 0.2% of the value of the estate taxes or whatever other fees are coming out are going to be greater than that. That's my humble opinion, but I understand what you're saying. Yes, Delegate Conway had a comment first, and then we'll go back to.
Thank you, Mr. Chairman. I just wanted to say this. If you've ever experienced it, or maybe you haven't experienced it, the breadwinner in the family let's say they're making 400,000 or 500,000 a year and they die, and everybody else is making 100,000 or 30,000 or 70,000. It's a terrible blow on the state. And I'm just you're throwing out these pointed percentage numbers, but the reality of it is this can be really devastating to an estate. So a person might have a $5 million estate, but you had a person that's making $100,000 or $400,000 a year and they die. I mean, that can be terrible to the people that are involved in the estate. You just need to keep a focus on what kind of effect it's going to have on the family. Thank you.
All right, thank you. So you have a motion, Delegate Cox, to hold the bill, or is there a different motion? What's the?
Yes, because
I thought this was going to be an easy bill.
Well, you mentioned too, I think I think Delegate Williams pointed out that there's an added fee already in the law. And it was pointed out to me and I'm not the best with math either, so correct me if I'm wrong, but if you, that's a 0.02%. So if you actually multiply that, it's 0.0002, that's only $1,000. So if you're gonna raise, this to a 0.2%, we're talking big money there. I do think we need to at least get some better numbers before we make a final judgment.
Is there anybody who had comments? I got you. Anybody who had comments on making it a amount certain versus a percentage? Is there any other thoughts to that before we move on to the next bill? Okay. All right. So I will see if we can get some more information for you, Delegate Cox. We will move on, but at least we're sort of, I think we're on the road here too, and we will move to the next one. I know I got people who are on the edge of their seats about where we are. We're more than halfway through. That's a good news. That's good news. 772, is that where we're on? Are we on 772 now?
Yes, that's correct.
Okay, whoops. Okay. Exemptions and from execution on judgments. This is Delegate Queen's bill. This is the one that Bob Enton's here to answer any questions on. This basically exempts $2,600 off the top from your savings accounts from the ability for a bank to go, or for an entity from garnishing your bank account.
I'm sorry, what's the bill number?
The bill is 772. From my understanding, and I'm gonna let everybody ask questions, but let me just tell you what my understanding is. Right now, you have the ability to have up to $6,000 shielded from garnishment, but you have to proactively file a form with the court. That form is somewhat onerous right now. And so therefore, if people don't understand how to, what this does is this automatically requires them to shield first $2,600 in your bank account from getting garnished without having to file anything. Now, I believe that the consumer rights advocates, as well as the the plaintiffs advocates on the other side, came out in favor of this legislation together. They did. I believe that they did. I know that the banks themselves were not in favor.
Not the plaintiffs. I think the defendants counsel.
Right, that's the consumer rights people, which I would consider the defendants, and the plaintiffs came out in favor. At least the collection side came out in favor of this legislation, from my understanding. However, I'm sorry, I'm sorry, they did not come out fully in favor. They came out saying, if I remember correctly, they came out saying that they are interested in coming up with a solution, but I don't think that there was actually testimony saying that they agreed with this legislation. They wanted to figure out a solution to the problem, if I remember correctly. They came out in favor on another bill that we'll deal with later.
They had some suggested amended language, which I think Bob might be able to speak
Okay,
to.
so I will ask Bob to chime in. Bob, if there's anything except for, you can forget about what I said about being in favor of opposed, but in terms of the technical side of the bill, tell us what, why there is a problem with this automatic 26, according to the banks, the banks believe that this is a problematic to have an automatic $2,600 exemption.
Well, thank you, Mr. Chairman. Robert Enton on behalf of the Maryland Bankers Association. I've represented the banks, I guess, for I think 36 years now, down in Annapolis. And I started out as a young lawyer doing collection work, and I'm pretty familiar with the process. We have, as Delegate Cardin said, right now, you can, if you look at the bill, you can claim an exemption for up to $1,000 in household furnishings, goods, apparel, et cetera, and you can claim an additional $6,000 of any other kind of property you want. So right now, you basically have pretty much a $7,000 exemption. That I have received copies of the forms that you file, and when the notice of the garnishment goes out to the garnishee and to the judgment debtor, it basically tells you, tells the judgment debtor they can file a motion to claim up to $6,000, but it's pretty much legalese, I think. And to my knowledge, not that many judgment debtors actually claim the exemption. I think most of the time these are default judgments in the district court. The judgment debtor is probably getting sued by maybe a bunch of different creditors, and I think they tend to ignore these things. From the banking industry's problem, if there's we have two issues, and I talked to Delegate Queen about this morning. She didn't realize that your subcommittee was meeting to take the bill up, and I've had very good discussions with her. The collection bar did not testify on the bill one way or the other. It was like 7 o'clock that night. I think I was the only witness that raised any concerns about the bill. It's my understanding that the collection bar is opposed to the bill, but I don't know what they've done and haven't done. The problem that we see with the bill is basically procedural. Even though we're often judgment creditors, that's not the point of view we're taking on this bill. Our problem is procedural. The bank has no way of knowing. We've never had an automatic exemption. You get an exemption for your social security check, but those checks are all coded, and the bank in their computer system knows that that's not subject to garnishment, period. And that has nothing to do with the amount of exemptions that you claim. The bank is not going to know whether or not the judgment debtor has exceeded has already claimed $6,000 in exemptions or $5,000. We have no way of knowing. I don't think the judgment creditor knows, and I think that's the issue. So we don't know. What I'm afraid of is that we're going to go ahead and not freeze. So what happens when the garnishment hits, the bank freezes the account. And then if the judgment debtor disputes it, they file something in the court. And then, it's between the judgment creditor and the judgment debtor. The bank just holds on to the money until it's resolved. If the judgment debtor doesn't file anything, then the judge is going to go ahead and sign the garnishment order. If the judgment creditor debtor says, look, that's a different Bob Enton. I'm not this is my account, but I'm not the Bob Enton that has a judgment against him. I'm not the Bob Jones, or the Tom Smith that has this judgment against him. And then if it's a back and forth between the judgment creditor and the judgment debtor. The judgment debtor doesn't say anything, then the garnishment's going to go through. The thing is, we won't know. I'm afraid we'll get sued because one part of the statute says that there's a $6,000 cap on exemptions, and the way the bill reads, the $2,600 is included in the $6,000. So if I claim the 26, then I still have the ability to claim 34 in exemptions. But if I've already claimed them and the bank doesn't freeze the money, the bank then have liability, because while new Section 5 says it's automatic, existing Section 5 says that you can't claim more than $6,000. That's one concern that I have, and I'm discussing that with Delegate Queen. We talked about it this morning. The second issue is from a mechanical point of view, the bank doesn't have the ability. Either the bank freezes it or it doesn't freeze it. And we can't, but my banks, and I talked to two banks over the weekend, one a large regional bank and one a small community bank. And they don't have the ability in their systems to say, okay, we're going to not freeze 2,600, but we are going to freeze, if there's more than 2,600, we are going to freeze 3,400 or whatever, 6,000, whatever that is. And they would have to, do this by hand somehow. Their systems aren't set up to do that, as far as I know, anywhere in the country. And that is a problem for us as well. I had suggested to Delegate Queen, and I'm trying to convince her this would be a good thing to do. And as I said at the bill hearing, I did talk to Judge Morrissey, that what we really need is a consumer-friendly form, so that if I'm a consumer and I get this form from the court, right, it says to me, you are in very plain, simple English, you can claim an exemption of $6,000. And here's what you do. Check this box, fill in the amount of up to $6,000 that you want to claim for the exemption, and that amount will be exempt. And mail it to this address. And that's kind of like, end of story. I think the bill's problematic from a procedural point of view.
We only have a couple minutes left, and we got to get into back to our committee. But let me ask you one quick question, Bob.
Sure.
Would you guys be okay? By the way, I just want to let everybody know that the DC Maryland Creditors Bar was unfavorable on this legislation. So
yeah.
And they were the only ones, other ones unfavorable. And the Maryland State Bar came in with some amendments, and maybe we can discuss that. But would you guys be okay if we required at the time that you are filling out a garnishment, that you're required to send the potential garnishee, the form that they can fill out to be able to, in other words, that the entity that's trying to garnish the wages is required to make sure that the person has this form, this new form, so that they can make sure that they have it and have a chance to fill it out? Prepaid.
Well, I will tell you this. So what I'm going to do when I know you've got a voting session at 11, I will send you the current forms from the district court. Our firm, my law firm, probably has the largest banking practice in the state of Maryland. We handle garnishments for half a dozen banks. So our lawyers in my firm that do that are pretty familiar with it. I can send you the forms. Those forms telling the judgment debtor what the judgment debtor must do are sent out by the district court. So they send that, they have a form and they send it to the bank, and they send it, the lawyer, the creditor's lawyer doesn't send it. The court sends it to the judgment debtor. I'll show you the form. And if you think that a judgment debtor understands what they must do when they talk about a garnishee and this and rule 2-245 and this, they're clueless, I think. And I really think that's the issue. From the judgment creditor point of view, is it, I'm not going to make their argument. They got their own lobbyists and, their own trade association. But I do think there's got to be a balance between, in this process, between both sides, and be fair to both sides. But I personally believe that, and I suggested to Delegate Queen, and we're going to talk some more about it. She wanted me to report back to her on what happened today, is that you could pass a bill which directs the Commissioner of Financial Regulation that regulates the banks to reach out to the judiciary during the interim and come up and report back on how this form can be simplified and made more consumer friendly. Because I do believe that's fair to both sides.
Yes, yes.
Just really quickly, because I know we're short on time. So
it's all right. They'll wait for us.
Massachusetts, New York, and California both do what is being proposed by this bill. So I guess my question for Mr. Eaton is, what about the banks in those states? How do they go about implementing this? Because clearly there are states that are doing this, and there are banks located in those states. So I guess that's my question. If you can just come back to us at a later date with the answer to that, that was fine. Because I hear what you're saying, but there's clearly states that are doing this and banks
So I
figuring
talked to a
something out
bank.
in those states.
I talked to a bank over the weekend that does business in New York State, and the bill has been a terrible problem for them. But I want to reach out. I talked to a regional bank. That was the regional bank, a Maryland bank. I'm going to reach out to like Bank of America and Wells Fargo because they do business in every state and
Right.
find out what issues they've had with this. You know, every law is different. But, you know, they may not have a $6,000, exemption like we have. So I think got to take a look at, when people come to the committee and they say, oh, this bill was passed in 6 states or 10 states, of course, but everybody's law is different. It doesn't mean they passed a bill like this bill. I don't know what, but I will find out and certainly report back to the committee. And I'll also send you the current forms that the district court sends out.
Thank you. All right, so committee, we have to discuss 848, 870, 1250, 1261, 1264, and 1266. We're going to reconvene at 4 p.m., hopefully after all our voting sessions. I was hoping we could avoid that today, but it's going to wind up happening.
Thank you for having me today.
Thank you. Okay, Bob.
Hey, Delegate Cardin,
yes,
are we using the same link at 4 o'clock today that we're currently using?
Yes, Dylan, Mr. Goldberg is nodding his head. We will use the same link.
Okay, thank you.
And we're going to try and bust through some of those bills. We don't have to vote on all of them, but maybe we'll get the SLAP legislation amendment drafted so we can vote on that.
Okay. Thanks.
All right. Thank you all very much.